Today we're going to be talking about life after OPT or optional practical training. We are going to talk mostly about some non-immigrant options, so focusing primarily on something called an H-1B. And then we will touch a little bit on permanent residency, just so you sort of have an idea of kind of the life cycle of what it looks like to be sponsored through employment, starting with the H-1B temporary status, and then going through to permanent residency or the green card. Okay, so we're getting our slideshow pulled up here. In the meantime, I just have a couple of, general disclaimers, of course. Immigration is a complicated area of law. Today we're going to be talking sort of generally about these different processes and the options that you might have. But it's always a good idea to get specialized, individualized advice from an immigration attorney, and make sure that you are talking to somebody who's qualified. Wary of getting advice from friends or relatives. Don't consult with a non-attorney. Pay attention to what the International Student Office is telling you, and make sure that you are getting advice from somebody who is used to working with international students and knows the nuances of things and issues that you all deal with. A couple of other tips, if you want to go to the next slide, just in terms of if you want to stay in the United States, usually completing a degree in an in-demand field is going to be helpful. If you are in a STEM field, science, technology, engineering, or math, then you will get some extra optional practical training time. You can look at the designated codes that are designated for STEM extensions on the SEVP website. They're delineated as what's called a SIP code or CIP code. Also, we found that internships can be a great way to kind of get your foot in the door and to ask questions at interviews about sponsorship and, do research on which employers sponsor for H-1Bs, who are familiar with the process, and, making a wise decision about who you're going to choose as your employer. All right. So if you want to stay in the United States following your F1 OPT, typically H-1B is going to be the classification that you want. Go to the next slide. So I know there are some limitations to H-1Bs, primarily in terms of the quota, which we'll talk about. But H-1B really is the best vehicle for people who are working in professional positions, so meaning positions that require at least a bachelor's degree. And you can find a link to employers who have sponsored H-1Bs in the past through this website. It does list them by the volume of H's that they have filed over the years, and also by region. So if you're curious to know in a particular area who sponsors H-1Bs, this is a good place to start. That being said, I work with companies all across the US that are both large employers and small employers. Every year we file H-1Bs for companies that have never sponsored an individual before. So you may need to educate them a little bit about what is required for the H-1B, or point them to an attorney who can help explain sort of what their obligations are and what their role in the process is. But by no means is this meant to limit you in any way, but it will give you kind of a good idea of what companies may be familiar with this process and willing to sponsor based on what they've done in the past. Okay. All right, so just a couple of basics, sort of the three kind of components that we look for in figuring out if an employer is willing to sponsor and if the H-1B is going to be a good fit, is that you have a degree, you're being offered a job in a field that requires your degree and that requires at least a bachelor's degree, and that your company is willing to pay you a certain wage, the required fees, and both legal and filing fees. And we'll talk in depth about each of these issues as we go forward. All right, so what are some other H-1B musts? Employment is limited to a specific employer. So H-1Bs are employer specific, job specific, and location specific. An H-1B can be part-time, and you can hold more than one H-1B, or what we would call concurrent H-1Bs, at the same time. Generally speaking, you're going to be limited to 6 years of total H-1B time. H-1Bs are granted generally in 3-year increments, and there are ways to extend an H-1B beyond the 6 years if you've taken certain steps towards becoming a permanent resident before you reach the end of your 5th year in H-1B. Your employment does need to be related directly to your degree. So if you're an accountant and you have an accounting degree, that's great. If you're an accountant and you have a business degree, but you have lots of accounting courses, then perhaps you could make a case for an H-1B, but there does need to be some connection between your degree and what is required for the position. In addition to that, H-1Bs are allowed to have something called dual intent, meaning the temporary intent to remain in the United States and the permanent intent to stay. So this is in contrast to the F1 or J1 status that you might have, where you're required to show only temporary intent to remain and a residence abroad. If you lose a job or quit a job, sometimes there may be a 60-day grace period in between positions that you can take advantage of. Of course, there are a limited number of H-1Bs for private employers, but there are some entities like universities that are exempt from the H-1B cap or quota. These include institutions of higher education and nonprofit organizations that are affiliated with institutions of higher education and some government research organizations. All right, so what does your employer need to do if they're interested in sponsoring you for an H-1B? They have to obviously agree to employ you as they're describing in the filings that they're going to submit to the government. So, no fraud. They also need to show a relationship between, the size of the business, the position that they're offering you, and demonstrate that they do have enough work to support a bachelor level position. So, if you're saying that somebody is going to be an accountant at a small family run restaurant, then that's probably not going to work because the level of work isn't going to be, of bachelor level work isn't going to be supported by a small family run restaurant. If you're talking about sort of a larger chain of restaurants, then perhaps you could make an argument that an accountant would be required to oversee and handle traditional accounting duties for, a larger restaurant chain. In addition, the employer has to agree to employ you in a specific geographic area. So one of the requirements is that they pay you a certain wage, which is called the required wage, and that's all determined by the job location. So in addition to being employer specific, an H-1B is also location specific and job specific. So you are able to list multiple work sites on an H-1B filing. But if you move to a work site that is outside of what's considered to be normal commuting distance from from those listed on the petition, then you would need to take steps to file an amended H-1B. All right. We can go to the next slide. All right, in terms of the wage obligation, the employer has to agree to pay you the higher of what's called either the actual wage or the prevailing wage. The actual wage is the wage that they pay other similarly employed individuals at the specific work site. And the prevailing wage is something that is determined by the U.S. Department of Labor. And it is basically a mean or median of wages for similar positions in a particular geographic area. And essentially what this protection is put in place to protect foreign workers from being taken advantage of and offered low wages, and also as a protection to U.S. workers. And so it basically means that the employer is going to have to pay you a competitive wage. There are 4 wage levels for each occupational classification. And the occupational classification is selected based on the duties that are of the position that are being offered. I have a link here to the Department of Labor's online wage library where you can search and look. But if we go to the next slide, you can see that we also have an example here of what this looks like. So for a software developer in Santa Cruz, the entry level or level 1 wage is going to be $86,861 per year. And that would be based on an employer requirement of a bachelor's degree and up to 2 years of experience. If the employer's requirements are higher than that, then the wage level will increase depending on what the employer's required for the position. And so it's also important to keep in mind that this isn't necessarily what you have in terms of degree and experience. It's what the employer requires. So if you have a master's degree in computer science, but the employer is only requiring a bachelor's degree, then you would still be at that level 1 wage. All right. A couple of other things to keep in mind. When an employer sponsors you for an H-1B, if they terminate you before the end of the H-1B validity period, then they are required to offer to pay for you to return to your home country. So it is a one-way ticket. It isn't to return all your belongings or your family members or anything like that, but they are required to offer you a one-way return transportation if you are involuntarily separated during the validity period. If you quit the position, then that obligation does not attach. They also have to do a posting, basically notifying other employees that they are filing something called a labor condition application. It gets posted at 2 conspicuous locations at the work sites, or can be posted, they can do an electronic posting. They do not have to recruit for the job, however. So it's basically just a notice that says that they're filing something called a labor condition application, which we'll look at. And there's a lot of times we hear from people that, the employer will say, well, I've tried to recruit US workers and I can't find anybody. That isn't required for an H-1B. It is required when you talk about employment-based permanent residency in most instances. But for an H-1B, they're required to do this posting, and then they can file something called a labor condition application. Also, they're required to pay the legal and filing fees. And we'll take a look at the next slide about what these fees are. And I do want to say that I'm sorry that this is so confusing. USCIS just came out with a new fee schedule that was effective on April 1st, and it can be kind of a head scratcher sometimes. And so we have there are several different scenarios and to figure out what fee your employer is actually going to pay. So in that second column, those are the fees for institutions of higher education and for people that are going to be exempt from the H-1B quota. So the basic filing fee, or the I-129, that's the name of the form that gets filed for an H-1B petition, for a CAP exempt or institution of higher education is going to be $460. That same fee applies to what USCIS determines as small employers. So those are employers that have 25 or fewer full-time employees. If the company has more than 25 employees, then they're going to pay the $780 basic filing fee. And that top row with the I-129 fees, that gets paid for all initial H-1Bs and all extensions. Then you go down to this anti-fraud fee. It's a $500 fee that gets filed with all initial petitions, regardless of employer or employer side. And that goes to fund USCIS's fraud investigations and what they call site visits. So USCIS does do random site visits to employers just to check that the information that they have put on the H-1B petition is actually true and correct. Then you go down to what's called the ACWIA or data collection fee. For large employers, it's either it's $1,500 and $750 for small employers. And then this new fee at the bottom, or this second to last fee here, the asylum program fee, that is a brand new fee that was just put into effect on April 1st. CAP exempt institutions of higher education are not required to pay this fee. But large employers are now paying a $600 fee and small employers a $300 fee. This fee is used to fund the government's asylum program. And again, is brand new. I know it's a hardship. The fees went up from $2,750, so $2,750 to $3,380 with the implementation of these new fees for large employers. So I know it is a big jump, but there was an attempt at litigation on this, but I think for the moment this is here to stay. And then the last fee you have is premium processing, which is a way for you to request that the government expedite the adjudication of your filing. The fee is $2,805. And it means that immigration will make a decision on your case within 15 business days. This is also a change effective April 1. It used to be 15 calendar days. Now it's 15 business days. And this is an optional fee that isn't always required. And this is one fee. So except for premium processing, the employer should be paying for all of these fees. And premium processing can generally be paid by the party that will benefit most from expedited processing. So that's something that would be determined on a case-by-case basis. All right, I kind of skipped ahead, so we can go to the next slide. So there were a series of judicial decisions that basically determined that having an employee cover these fees would be an improper reduction of the wage below the required rate of pay. And so if the employer refuses to pay it, well, most of the time you're not going to find an attorney that wants to work with you. If they have questions, if they're not sure about why this is the case, I would encourage them to speak with an immigration attorney who can explain to them the liabilities that they could incur and the potential penalties and fines if they are found not to have complied with us. All right, so with that, I want to talk a little bit about the H-1B lottery. Next slide. So for anyone who is not an institution of higher education or a nonprofit affiliate, government research organization, so basically meaning a private employer, they are going to be required to go through an H-1B cap or a lottery. And this year was I believe it's the fourth year of an electronic registration. But USCIS did roll out a new updated system this year for H-1B cap lottery submissions. For 2024, the filing window was from March 1st to March 18th. And that's pretty typical. They generally will open up H-1B cap registrations early to mid-March for about a 2.5-week period. And essentially that everyone who registers during that 2.5-week period who has a proper registration will be considered for the H-1B lottery. They do view it as fraud if more than one employee, they can view it as fraud if more than one employer registers for the same person, particularly if they are affiliated entities. So if you have a parent company with 5 subsidiaries and they try to register you, 5 and 6 times, then you will likely have all of your registrations rejected. In addition, this year, USCIS did what they claimed to be what they call a beneficiary-centric H-1B cap selection. So basically, instead of going by the petitioner or the employer, they went by the foreign national or the employee / beneficiary. And so they reviewed the passport information, which is what is collected when you submit an H-1B cap registration, and tried to eliminate duplicate registrations for the same individuals. And you'll see in a couple of slides, I have some statistics about this, so you could see why this is so important. The process is all done electronically through something called My USCIS, which is an online portal. And immigration does notify employers and attorneys, if you have an attorney, whether or not they've been selected in the lottery. So you can log in and see that your registration was submitted. You can log in and see that you've been selected, and then download that selection notice. If you are selected in the lottery, then you are invited to submit your full H-1B petition. And usually you have 90 days to do that. In the past couple of years, or just, I think not last year, or last year they did more than one round of selections. The year prior to that, they did not. And then the year before that, they did 3, I believe. So there is a chance for a second round of lottery selections, but USCIS is still going to pull from that same initial pool of folks that registered the first time. So they don't open it up to additional people. In addition to that, H-1B status generally takes effect on October 1st. So that is the earliest start date that an employer can list on an H-1B petition. And if, generally speaking, if you are selected in the lottery and you have an H-1B that is approved, we typically would recommend that you wait until at least after October 1 and go and show up for employment with that H-1B sponsor and work for them and get at least one paycheck before you decide to move on to another job. All right, next slide, please. Thank you. So if you're selected in the lottery, what do you need to file? The first step is typically something called a labor condition application, which gets filed with the U.S. Department of Labor and takes about 7 days to get back. In this LCA, your employer is attesting that they're going to treat you like they would any other U.S. worker. They've offered you all the same benefits as they do their regular, all of their other employees, that they don't have any strikes or lockouts or layoffs, that they're going to pay you the salary that meets the prevailing wage. And once that is certified, then you can submit the form I-129 with the H-1B supplements to USCIS with the certified labor condition application, evidence of your bachelor's degree. We usually include some kind of support letter from the employer explaining what the job is and outlining the duties, what the offered salary is, what their education and experience requirements are, and how you meet that standard. These applications get filed, and I should also add evidence of your immigration status. So showing that you're maintaining your status and will be maintaining that status up until October 1st, provided that you're in the United States. This all gets filed with one of the USCIS service centers, and they will issue receipt notices. You can track the status online once you have that receipt number, and then they will either approve it, deny it, or issue a request for additional evidence. They could also issue something called a notice of intent to deny. In my experience, if USCIS isn't satisfied initially with the evidence that's provided, then they will issue a request for evidence, or what we call an RFE, and then you'd have another opportunity to address whatever their concerns are. Blanket denials are pretty rare. And if you're maintaining your status in the United States, then you generally do not need to leave the US. You can apply for a change of status. So basically you change from F1 OPT to H1B without needing to depart the United States. You're not required to go get a new visa. If you are a current or former J1 who may be subject to the 2-year home residency requirement, then you may not be eligible for H1B. You may not be eligible for a change of status, but that's something that you need to talk to an attorney about pretty carefully. If you are outside of the United States, then you would need to get a visa to return. Or if you travel outside of the United States after the H-1B is approved, then you do need to get a new visa stamp in your passport in order to get back into the United States. The only exception for that is going to Canada or Mexico for less than 30 days and not obtaining a visa or applying for a visa through something called automatic revalidation. And I should also add that if you are a citizen of Canada, then generally you would be considered exempt from the visa requirement. All right, so once you have the approval, then so getting the approval, I guess I'll go back to, generally USCIS takes between 3 and 7 months to adjudicate these types of applications. They do tend to prioritize them and try to get them all approved before October 1, which is the earliest start date for the H-1B petition. That's the date that it will take effect, unless it isn't approved until after that date. And then, as I said before, you know, we do recommend that you show up and work for that employer for at least one pay period before you decide to move to another entity. So just to talk a little bit more about that, once you've been counted in the H-1B quota, you generally don't need to be counted again. And once you've been counted, you have that H-1B approved, you've worked for that employer, you can move or port to another employer through a change of employer petition that gets filed with USCIS and start working for that new entity upon the filing and receipt of that application. But the most conservative thing to do is to wait for the approval. You have to wait for the approval. And the most conservative thing to do is to actually go and work for them before after October 1. All right. So what is the quota? There is a limit to the number of H-1B visas that are available every year, and currently the limit is 85,000. Of that, about 20,000 of those are set aside for people who have earned U.S. master's degrees from accredited institutions of higher education or higher. 6,800 are reserved for citizens of Chile and Singapore through for a visa classification called an H-1B1. And then the remainder, so about 58,000, a little bit more than that, are available for what we would call the bachelor's cap, or basically people who have no U.S. master's degree. So even if you have a foreign master's, you don't get to go under the master's cap. It has to be a U.S. master's degree. All right. And then what does this all look like in practical numbers? I don't think USCIS has released the numbers for this year. So in the column all the way on the left-hand side, that's for fiscal years. So that's the government's fiscal year. We're technically now in fiscal year 2024. The government's fiscal year starts in October. So the cap that just ran this year is for fiscal year 2025. But last year, you can see that USCIS received over 780,000 H-1B registrations. Some of them were improper, so they kicked them out. And then of that 758,000, over 400,000 of them had duplicate employers register them. So basically meaning the same individual had multiple employers submit H-1B cap registrations for them. You can see that they selected 188,000 application, or so they made 188,000 selections. They do have a formula that allows them to estimate the number that they need to select to fill the quota based on what they will deny, based on people who won't file, based on duplicate registrations where they know only one company is going to end up petitioning for them. But last year we did see towards the end of the summer that they did do another round of H-1B selections, I think for this reason. So I don't know this year, kind of what the numbers looked like. Another consideration, not this year, the registration fee per registrant was $10. Next year is going up to 200 and something. That may deter people from submitting so many registrations, but it is relatively easy to register someone. And so I think that's part of the reason why it accounts for just the large number of registrants that you see. All right, so who's exempt from the H-1B quota? As I said, if you've already been counted in the cap within the last 6 years, generally you would not need to be counted again. If you work for an institution of higher education, like UCSC, you don't need to be counted in the quota. If you work for a nonprofit research or government research organization, that would be an organization whose primary purpose is to engage in research, then you are exempt. But not all government entities are research organizations, so you can't necessarily work for a state entity and be exempt from the quota. And not all nonprofits are quota exempt either. If you work at a nonprofit, though, that is affiliated with an institution of higher education, then you may be exempt from the quota. In my practice, we see a lot of K through 12 schools who have some sort of written affiliation agreement with a university, usually for their education students to come and do student teaching, or perhaps the K through 12 students are able to attend courses on the college campus for college credit. They may be eligible for filing under quota exemption, but that's something that you'd have to look at pretty carefully. And then also people who work at an institution of higher education may be exempt from the quota, even if their employer is a for-profit business. So let's say your company runs some sort of services on a university's campus, perhaps you would be exempt from the H-1B quota. You can also have a concurrent H-1B with a cap exempt employer, and then file a concurrent H-1B with a for-profit business, a normally cap subject business, and be exempt from the quota. So if you have an H-1B with the university, and then you have a second H with a private employer, then you can do that as well. One other thing to talk about in terms of the H-1B and the timing and how you make that transition from OPT to H-1B is something called the cap gap. So in April of 2008, USCIS and SEVP rolled out something called cap gap, which basically allowed students to stay in the United States from the end of their OPT to October 1st to cover this gap period that was occurring otherwise. So essentially, students who who are selected in the H-1B lottery and have an H-1B petition filed for them before their OPT expires are able to stay in the US and get an automatic extension of their OPT while they're waiting for October 1st. So as long as the OPT is valid on the date that the H-1B petition is filed, they get to, you would get to have an extension of your work authorization through September 30th. And that way you don't have to leave the US and you can continue to work. You don't get a new OPT card. Instead, you would just get what we would call a CAP-GAP I-20, so an updated I-20. And you are allowed to stay in the US and work during that time. If your OPT expires before you can file the H-1B petition, so let's say you're in your 60-day grace period following the end of your OPT, but your H-1B is able to get filed within that grace period, then you can stay during the CAP-GAP period, but you are not allowed to work. All right. Another thing that comes up pretty frequently is travel. Can you travel while on the CAP-GAP? The short answer is no. You can, in order to be eligible for travel while on OPT, you are required to have a valid EAD card. And since you do not have that during CAP-GAP, then you are not eligible to travel during that period of time. All right. Another question that we get frequently is about self-employment. So can I sponsor myself basically for an H-1B? And I think the short answer is no. The more detailed answer is probably not, but we'll explain why. So under the current guidance and regulations, in order to qualify for an H-1B, there needs to be some sort of employer-employee relationship between you, the foreign national, and the employer that's filing for you. And basically what that means is that the employer needs to be able to hire, fire, review your performance, and all of those good things. And so if you're self-employed, obviously you're not going to fire yourself. You're not going to review your own performance. So there's no employer-employee relationship. In addition, USCIS may say, well, if you're sort of a one-woman show with your own business, like, are you really only performing bachelor level or specialty occupation work? And the answer is, probably not, maybe. There may be a way to have an independent board of directors that can, review your performance or fire you or sort of supervise you and assign duties. I have never seen a case like that. And I think that's something that would, have to be really carefully constructed and developed in order to make a successful case with USCIS. And in addition, if you're a startup company, then there may be questions about whether or not you have the ability to pay the required wage. What is your startup capital? Where is that coming from? And so for all of these reasons, self-employment on an H-1B is, very difficult. There are some proposals for changes in this area, but there was no time frame, unfortunately, for how that might all kind of roll out. All right. In terms of workarounds, I know the H-1B quota is just very limiting, and a lot of people are disappointed every year, which makes it really difficult. There are a couple of different workarounds. None of them are necessarily kind of ideal. Again, the H-1B really is the best visa classification for people who work in bachelor level positions, but for the lottery. Some of the workarounds that we've seen people do in the past are enroll in a new course and do what's called day one CPT or curricular practical training. You do need to be kind of wary of these programs. There are a lot of programs that are not reputable. So it's important to make sure that you're kind of vetting the program and asking them about this. Basically, that would allow you to go to school and to work at the same time. There's also a trainee visa called an H-3, which is valid for 2 years, but the training needs to be for a job abroad, and it really needs to be a detailed training program where the employer is evaluating you based on different skills and tasks that they expect you to achieve. You're not supposed to be doing on-the-job training. And so it really is not generally a good fit for people who really want to work full-time in a bachelor level job. Also, there may be a J1 trainee, but you would have to go abroad for a period of time and then come back as a J1. Or if you work for a multinational company, they may be able to transfer you abroad for a year and then bring you back in L1 status as a multinational executive manager or somebody with special knowledge. And then there are two private companies that got creative or that were sort of developed out of this sort of the limit of the H-1B cap. One is a company called Mod Squad. It's only for IT workers, and they will work to place you in Canada and then basically contract you back to your US employer. And the other is something called Open Avenues, which will match you with a cap exempt employer, and then you can file with your cap subject employer. I'm not endorsing either of these. Truthfully, I've never had a client use any of them, but I just want you to know that there are options out there. People have gotten really creative, and I think they could be. I think both of those companies are reputable, but obviously everybody needs to do their own kind of due diligence on that. All right. So are there any other alternatives? If you're a citizen of Canada and Mexico, then you may be eligible for something called a TN, which is part of our treaty, the US Canada-Mexico agreement, formerly NAFTA. There's an enumerated list of occupations that are eligible for TN status. So that may be an option. Most of them are pretty straightforward, except for something called a management consultant and people who work as scientific technicians or technologists. But for engineers, for academics, for certain computer science positions, then the TN may be an option, but there is no dual intent, meaning that you do have to have only the temporary intent to remain in the US. Typically, these are given in 3-year increments, but there is no limit to the number of TNs that you can get. All right. And then we have a couple of other alternatives for people from Chile, Singapore, or Australia. These are also based on treaties. The H-1B one is for Chileans and Singaporeans. And it's essentially like an H-1B granted in 1-year increments and requires a residence abroad. And then the E3 is also essentially like an H-1B just for Australians. So, those are potentially some other options. And then we have the J1 for researchers, professors, scholars. There's sort of a whole host of options for J1s that may be available. All right. And then just a couple more. The O1 is for persons of extraordinary ability. So if you have, usually this would be reserved for people with PhDs. If you have publications, citations, you've done journal review, you've done conference organizing, then perhaps you may be eligible for an O1. There's no quota on the O1, so that can be a good alternative. And then if you are thinking about self-employment, really the only option there is something called an E1 or an E2, which is a treaty trader or a treaty investor. Sort of the first step in looking at this is, does the US have a treaty with your country of citizenship? And you can find that on the Department of State's website. And essentially that means that you would need to make some sort of investment. We typically say, less than $50,000. But it would depend on the type of business that you're investing in, what the overhead is, what the startup costs are. or if you're buying an existing business, what the value is and how much you invested and what your percentage of ownership is. In addition, if you work for a company that is that shares the same nationality as you, and you're working as an essential employee, then you may be eligible for an E2 employee visa. So basically, if you're working for a company that's Canadian owned and you are Canadian, then perhaps the E1 or E2 would be, the E2 employee would be an option for you. I think we talked about the L1 already. So with that, I think we can pause for questions. We are going to talk about permanent residency next, but if anybody has any questions about H's, about non-immigrant classifications, I'd be happy to answer those on the number of visas that can be issued in a particular year for that category. A permanent resident can also sponsor their spouse and their unmarried children, both over and under 21, but they are subject to a quota. U.S. citizens can also sponsor their siblings and their adult married children, but they are also subject to a quota, which means that there are backlogs and that these individuals in these categories will wait until they're able to apply for permanent residency. People who have been granted asylum in the United States are also eligible to apply for residency after a certain period. We do have something called what you may hear of as an investor green card, or EB-5, which requires an investment of either $500,000 or $1 million and 10 full-time U.S. workers. Certain victims of domestic abuse, human trafficking, or crimes may be eligible. And some people can be eligible if they are put into removal proceedings, if they have certain U.S. citizen relatives. But today we're really going to talk about employment-based permanent residency, but I just wanted to give you all a flavor of other things that may be out there. One other thing to talk about is something called the Diversity Visa Lottery. So the Diversity Visa Lottery is something that is controlled by the Department of State, and they publish every year instructions on how to apply. Normally it's in the late summer, early fall, and the purpose of the DV lottery is to encourage immigration from countries where we have historically low levels of immigration. And so there are a limited number available every year, and they publish a list of citizens who are not eligible to apply, basically because we've received more than 50,000 natives of this country have immigrated to the U.S. in the previous 5 years. So this is a list from last year. And I will say that there is a lot of fraud and scams associated with the DV lottery. So if you are going to apply, make sure that you're only doing it on the State Department's website. You don't need to pay anyone to do it for you. It is a true lottery process. But if you're interested in learning more about it, I would go to the Department of State's website. They do have a lot of really good information on the process and the timelines and what the steps that you need to take to do it. All right, so with that said, what we're primarily going to talk about is employment-based permanent residency. So there's sort of one of two formulas or general steps to becoming a permanent resident through employment. The first one is a 3-step process that is labor certification, or PERM, P-E-R-M, then the employer petition, or I-140, and then last, adjustment of status, or I-45. Some individuals are going to be exempt from this labor certification requirement, and they can just start the process with the employer petition or I-140, and then do adjustment of status. So what is a labor certification? So this is different than the labor condition application that's associated with the H-1B. And the labor certification is a test of the local labor market to demonstrate that there's no U.S. worker who's willing, able, or qualified for the position. And this is done through a series of ads. The employer for most positions is going to have to do 2 consecutive print Sunday ads, and then do 3 additional recruitment steps to try to demonstrate that they tried to find a U.S. worker, but that they were not able to do that. The employer isn't generally allowed to require things that would not be considered normal for the job, basically to exclude other people. So let's say that you have an accountant and you're saying, I require this accountant to speak Spanish. That would not be considered a normal requirement. And if you do require things that are abnormal, then the Department of Labor will audit you and ask you why, as a business necessity, you require this thing that they consider to be out of the norm. In addition to that, an employer has to agree to pay you a prevailing wage. For labor certification purposes, the employer or through the attorney is going to need to file a prevailing wage determination with the Department of Labor. And so the DOL is going to look at your job description, what the employer requires in terms of education and experience, the location of the position, and then they're going to say to the employer, hey, employer, you have to pay X number of dollars to this individual in this position at the time that they become a permanent resident. In addition to that, the employer generally needs to have solid financials. We see usually when a company has more than 100 employees, this is not a problem. But for smaller employers, because of the way that they do their taxes, a lot of times they show a loss. And so the government takes a pretty narrow stance on how you approve this ability to pay the prevailing wage. So that can be something that, needs to be looked at and should be looked at the beginning of the case to make sure that, if their tax returns show a loss, that there's a plan of how you're going to figure out how you're going to demonstrate that you can pay the prevailing wage. In addition, the employer has to pay all of the attorney's fees and the costs of the ads. And that is by regulation. So there's no kind of wiggle room around that. And then the only other thing to keep in mind is that I know a lot of times there's confusion about the labor certification, which is for the permanent process, and the labor condition application, which is only for H-1Bs. So the labor certification right now takes the process kind of from start to finish, takes about 2 years. So, it is a good idea to start early if you can, because that will give you more time to hopefully to extend your H-1B. You'll be able to extend your H-1B if you need to beyond the 6 years. And also it will hopefully mean that you get your permanent residency faster. All right, so who is exempt from the labor certification requirement? There are a couple of different kind of occupations or folks who are exempt from the perm requirement. And so basically what that means is that they come into the process starting with something called an I-140. And so if you are working in the national interest and you have at least a master's degree, then you may qualify for something called a national interest waiver. The legal standard for the NIW, as it's called, was given by the courts in a case called Matter of Danosaur. And essentially it said that the person needs to be working in a field that is of national interest and of substantial merit, and that they have to be well positioned to advance what they call the proposed endeavor or the field, and that it needs to be demonstrated that on balance, it would be beneficial to the United States to waive the normal labor certification requirement or that test of the labor market requirement. For these types of applications, an individual can self-sponsor. And here, typically what we're documenting and demonstrating is that the individual has published, that they have citations to their work, that they've done journal review, that they are, and then really outlining what it is that the individual is doing, why it is in the U.S. national interest, and then what it is that they plan to do when they get their green card. This type of petition doesn't require an offer of employment per se, but USCIS frequently will issue a request for evidence asking for more details about what the individual actually plans to do once they get their green card, just to make sure that, they do plan to continue working. And there is a reasonable chance that they're going to continue working in that field and contributing to the U.S. national interest. The other self-sponsored option is something called an extraordinary ability. And essentially this is limited to people who have risen to the very top of their field of endeavor, and they may self-sponsor. You can do this through either a one-time award, like a Nobel Prize or an Oscar. I don't have any clients like that, so we revert to the sort of the alternative, which is demonstrating that you meet 3 of 8 enumerated criteria. And so those criteria are that you've published scholarly works, that you've judged the work of others. So, you've done journal review, maybe you've done editorial work, you've done conference organizing, that there is published material about your work. So not just sort of a brief mention of you, but that there are publications that talk about your work and why it is important, that you've received work of national awards that are recognized for outstanding achievement, that you've worked in an essential or critical capacity for organizations of distinction, that you commanded a high salary, so things like that. These types of applications are very document intensive, and really require an individual to demonstrate, again, that they've risen to the very top of their field, that they're nationally or internationally recognized as outstanding, as extraordinary. And typically what we would do in this case, in addition to getting like the independent evidence of publications and journal review and things like that, is get a series of expert letters from people in the field who can attest to the caliber of the individual's work and why it is important, and why they've made significant achievements. In addition to that, so even if you meet 3 of the 8 criteria here, there is something called a final merits determination that USCIS will look at, which basically is, okay, yes, you have publications. Yes, you have a journal, you've done journal review. Yes, I see there's a couple of articles written about you. But are you extraordinary enough, essentially, to just meeting the 3 of 8 criteria isn't enough. You have to show like, what is that little something extra that makes this person so extraordinary, that that they should be approved for this extraordinary ability. And I should say, kind of the benefit of doing the extraordinary ability, and the next one that we'll talk about is the outstanding professor or researcher, is that it does give you kind of a more favorable position in applying for permanent residency. We'll talk about sort of that and backlogs in just a few minutes. But they do require a lot of documentation. In addition to that, for extraordinary ability and for outstanding professor or researcher, since we're trying to prove international or national renown, generally USCIS isn't interested in things that originate from your home institution, so from the university that you're working with currently, or from your PhD issuing institution. So I know a lot of academic institutions have regular publications with overviews of research that's being done on campus. When we talk about publications about your work. That's not what we're talking about. Same thing with same thing with awards, rather. Travel awards generally wouldn't be considered. Any on-campus awards from, either the PhD institution or the current institution really wouldn't be considered, because we're trying to show that the reach of this person, the expertise of this person is known beyond, kind of the sphere where they normally operate. Outstanding professor and researcher is fairly similar to extraordinary ability, except here you just there's a couple of differences. First, the individual has to either be in a tenured track position as a professor, or they need to be in what's called a quote unquote permanent research position, meaning that the research that the position needs to be of an indefinite duration with reasonable expectations of continuing, should there be favorable conditions. So here, the individual also needs to demonstrate that they have at least 3 years of experience, and that they are of national or international renown. So again, here we'd be looking for things like publications, citations, journal review, publications about the individual's work. We also use expert letters here, and these top 3 applications do require extensive documentation, a lot of collaboration between our office and the foreign national in terms of successfully putting together a case like this. The last I'll mention is for nurses and physical therapists. The Department of Labor has designated these as shortage areas. And so if you are a physical therapist or a nurse, then basically you do something called a Schedule A labor certification, which means the employer has to do a prevailing wage determination, but they don't have to do the full labor certification, and they can just essentially jump in at the I-140 stage. So in terms of sort of timelines and how this all works and who has to wait, when you first take that step of applying for permanent residency, so either through filing of a labor certification with an employer or filing the I-140 petition, then you are establishing something called a priority date, which is your turn in the line to apply for permanent residency. And this is all determined by your country of birth and the category that you're filing in. So for country of birth, I just want to emphasize that it is country of birth, not country of citizenship. So even if you were a citizen of India, but you were born in India, but acquired Canadian citizenship, you're still considered to be Indian for purposes of when you can apply for permanent residency. In contrast, if you were born in the United Arab Emirates, but you're a citizen of India, you are what they would say chargeable to the United Arab Emirates. The only exception to this is if your spouse was born in a different country, then you can do what's called cross-charging. So if you're Indian and your spouse was born in Bangladesh, even if you are the Indian national is the sort of the principal or primary applicant, then you are cross-chargeable to Bangladesh, and you may be able to apply for your residency much more quickly. And so historically, we'll see there's a quota on the number of immigrant visas that can be issued every year. And historically, we've seen long backlogs for citizens of India and China. Essentially, basically what that means is that they need to wait quite a long period of time before they're able to apply for permanent residency. So what this basically means, and you see sort of this chart is from what's called the Visa Bulletin. The Visa Bulletin is published by the U.S. Department of State every month, usually in the middle of the month for the following month. So in the middle of April, they'll come out with a bulletin for May. And it lists some dates and basically when you might be eligible to apply for permanent residency. So they're broken down into categories. In that first column on the left, you see first, second, and third. And then across the top, you see all chargeability, which basically means people who were born in all countries other than China, India, Mexico, or the Philippines. And then first preference is that outstanding professor or researcher or person of extraordinary ability. And so you can see that for first preference, India, people who filed their I-140, so their outstanding professor or researcher extraordinary ability petition on or before March 1st of 2021 are now able to apply for residency. If you go down to second preference, that is for people who are in positions that require at least a master's degree or a bachelor's and 5 years of experience. For India, people who filed that labor certification or a national interest waiver on or before April 15th of 2012 are going to now be eligible to apply for residency. So you can see, unfortunately for India, the backlogs are quite significant. And while you're waiting for your priority date to become current, then you are, basically you're required to maintain some kind of status in the United States up until that point where you can actually submit the I-45 application. So unfortunately, just filing a labor certification doesn't give you the right to work or remain in the United States. The same thing with the I-140. You're not allowed to work and remain in the US just based simply on having an I-140 filed or approved. It's not until you get to that final step of submitting the I-45 application that you have separate authorization to remain in the United States and are also eligible to apply for a work and travel permit while you're waiting for the I-45 to be approved. Just a couple of other final thoughts in terms of finding an immigration attorney. Obviously get suggestions from your employer, talk to your friends or your school, ask people for references. Unfortunately, there are a lot of attorneys or notarios or people who may appear to be attorneys out there who really kind of don't know what they're doing. Immigration is pretty complicated. And so, like in our office within, what might seem like a very narrow area of law of immigration, we all specialize beyond that. And so making sure that you're doing your research, finding somebody who is reputable, who knows the process, who's handled these kinds of cases before is really critically important. In addition, immigration is is federal law, so you're not limited to someone who is in your geographic area. For instance, my law firm is based outside of New Orleans, but we work with clients all over the country. And so, it gives you more options in terms of who to work with and finding somebody that really has that area of expertise. In addition, most immigration attorneys do charge a flat fee. It's fairly rare for it to be hourly. So I think that's something else that you can look for, and making sure that, when you're asking about what the fees are, that you're really clear on what services are covered by any fee that you're being quoted. And obviously, don't sign anything that isn't true. Don't work with anybody who wants you to misrepresent a situation. And so, with that, I think we can, I think we have about 15 minutes.
This is going to conclude our presentation. And so thank you for joining us for the Beyond OPT workshop.
Thank you.
So Elaine, you want any closing words?
I just want to thank everybody for attending today. I know the recording will be shared. All my contact information is on there. So I'd be happy to answer any questions that you might have as a follow-up. But otherwise, I thank you for your time.
And Lacey, would you like to say something?
Thank you for joining. Hope to see you soon.
And I'm the office manager. I'm Christine Redshaw. Our office is located in Classroom Unit Building. The front office is room 103. So if you're familiar with Classroom Unit Building, unit 1 and 2, where all the lectures are, come into the hallway and you'll come into room 103. Our front office is open Monday through Friday, 9 AM to 12 PM. We're closed from lunch from 12 to 1, then you can come again from 1 to 4 PM. We are also available, we have remote appointments available as well as in-person appointments. So you'll want to go to this website, issp.ucsc.edu. Again, that's I for international, SSP, student services and programs, issp.ucsc.edu. Go to the advising page and you'll find Lacey on there, and you'll find other advisors, and they can help you via appointment. So you can schedule your own appointment on that website. You can also call our telephone number, 831-459-2858. And you can also email istudent@ucsc.edu. Thank you for joining us.